Oh, shoot. Lost my minutes. I'll be right back. I'm not calling the meeting to order. Okay, sorry. Calling the meeting to order. Will the clerk call the roll, please?
Notice is hereby, oh, sorry. Dillard Meyer. Eisenman.
Here.
Esri.
Here.
Furtado. Goss.
Here.
Harper.
Here.
Ingram. McGuire.
Here.
Patterson. Rector.
Here.
Storr. Summers.
Here.
Taylor. Thorsland.
Here.
Tinsley.
Present.
Vachaspati.
Here.
Wolkin.
Here.
Young.
Here.
Clemens.
Here.
Clifford. Court. Rosales.
Miss Howard is here. She's just in the other room, but we wait till she comes in to say she's here. And Miss Taylor, well, she just came in. Yeah. So Miss Taylor just came in. Okay. All right. This is the season of Thanksgiving. And tonight we're going to do a prayer from Teresa of Avila from Spain in the 1500s. May you be blessed forever, Lord, for offering your hand of love in my darkest, most lonely moment. May you be blessed forever, Lord, for putting up with such a stubborn soul as mine. May you be blessed forever, Lord, for continuing to pour out your blessings upon me, even though I respond so poorly. May you be blessed forever, Lord, for drawing out the goodness in all people, including even me. May you be blessed forever, Lord, for being constant and unchanging amidst all the changes of the world. May you be blessed forever, Lord, for your countless blessings on me and all your creatures. Please rise for the pledge.
To the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, will the clerk read the notice of the meeting, please, and make note that Ms. Coward arrived.
Notice is hereby given that a regular meeting of the County Board, Champaign County, Illinois, will convene on November 21st, 2019, 6:30 p.m. in the Lyle Shields Meeting Room, Brookins Administrative Center, 1776 East Washington Street, Urbana, Illinois, in said county for the purpose of allowing and ordering payments of claims against the county, receiving and acting upon reports of committees and such other matters as may be brought before said meeting, which said meeting shall continue in session from day to day until the completion of said business.
Okay, thank you. We're now to approval of the agenda. I would like to mention that the ELEC meeting on December the 5th has been canceled. And I think we have something on the consent agenda that doesn't belong there. Lorraine, do you want to pull that? Pull it off the agenda? Yeah.
Ask to pull item 3C of consent agenda.
Okay, we're going to pull that off the, item 3C off of the agenda. That's the meeting calendar for next year. We're pulling it for a change to occur. Okay, are there any other changes to the agenda? Can I get a motion to approve? Mr. Goss, Ms. Taylor, any further discussion? Those in favor?
Aye.
Those opposed? Motion carries. Okay, next is the list of the regular meetings. We have taken out the ELEC meeting. Public participation. We have some members of the public here wishing to speak tonight. If I call your name, when I call your name, would you step to the center podium, push the button in the center for the microphone to go on? Oh, Mr. Goss is going to get that for you. And each person will have 5 minutes. There's a total of 1 hour if we have a lot of speakers. So the first person to come would be Casey Osterber, please.
Good evening. My name is Casey Osterber. I'm from Penfield. The reason I'm here this evening is to discuss, or I guess voice my opinion, about the unincorporated towns regarding their recreational cannabis that you guys are going to vote on this evening. The towns that these are affected by are very small towns, with one with 200 people, one with 300, and Dewey having right around 900, which is, I would say a majority of that is probably out-of-town people. Everywhere you turn in these towns is residential. There is no structured business area. So for those of you that live in town, how would you feel if one of these businesses was within walking distance of your homes? I understand that from a medical standpoint, there are many benefits, but this is recreational, and that comes with all sorts of people that would be attending these business, I guess. These towns do not have any law enforcement. They don't have any law enforcement to them. Where we live, which is the most northern east point of the county, and the county police station being right across the street, it takes a good 30 minutes for somebody to show up. That's if they show up. So if an issue comes up, how is it going to be handled? There are no laws that have been put in place on this. So at the very least, I ask that you guys consider, since you have 12 months to vote on this, stepping back and seeing how this works in the towns that are doing it, to see how they handle situations before you decide on these small towns to have these businesses. I had a lot more stuff to say, and now I can't remember everything. But that's the main thing. We are very small towns. Many of these towns don't even have businesses in them, and we don't want to see something come into our business where there's potential to have strangers to us coming into our towns. A lot of these towns have small children in them. I'm a mother of 2, and allowing in the town we live in, going down and playing at the basketball court when there's a business across the street with people that we're not familiar with. I mean, how would you like it if there were unfamiliar people coming into your neighborhoods that you didn't know, and you were sending your small child down to the playground to play? I'm not saying that everybody's bad, but there are potential to be problems, and we don't have any police force to regulate that. So at the very least, see how it goes in these bigger towns before you affect our little small towns, since there are very few of us. So that's all I got. Thank you.
Thank you. Would Linda Reynolds please come up?
Thank you. I am from Urbana. when my husband, I was raised in Champaign, but when my husband and I got married, we crossed the street and moved to Urbana. So I want to speak in today because I'm here to speak about how I'm prayerfully hoping that you would consider not building a new jail. Our problem right now is not the fact we have like an instance, maybe I can give you a for instance. My father was a Korean veteran. He was a very good person, but you know where he could find comfort in conversation, who understood what that was like, was with his friends who also were in the Korean War. So they would get together, they would talk. For a real instance, my husband was hit by a car, and he had trauma, and he passed away. I have a son, my oldest son, who passed away from terminal illness. So if I'm going to talk to somebody, okay, I can't talk to somebody that only understands trauma when I'm needing to talk to somebody that understands terminal illness. When we have people who have these problems, these are people who are going through things in life that happen. And when they happen, we need professionals who qualify, okay, to be able to talk at that level, to be able to help at that level. It's not just one somebody, you know, and it's something that demands a place to be. It's something that needs to be incorporated. It's something that needs to be here. It needs to be here to help counseling for families, for children, for mothers, for fathers. I mean, you can't try to fix somebody and then send them back home, okay? And what happens? You know, it's all over again. It just doesn't work that way. And I'm asking you as a county to help us make wise choices, to be able to help all that we can help. It's not a jail, you know. A jail is for people now, okay? But the magnitude that we're talking about that's happening right now is not just here in Champaign County or in Illinois. It's a national issue. And the problem is putting a Band-Aid on something and spending all this money, okay, to make, excuse me, Wall Street rich and the investors richer is not how it should be. I'm tired that I do a lot of advocacy work, okay? I do a lot. I talk to General Assembly members in New York. I talk in Washington, and really right now Washington is not real happy. But all I want to say to you is that they ask me, why am I here? I say, because you know what, your state is my state. What's going on here is going on in my state. It's got to start somewhere. So why can't it be in my state? Why can't it be in my county? Why do we have to watch people be harmed, be put, you know, for things that could be helped? It's not about a psychiatrist in medicine. It's about somebody being able to talk to somebody, to help somebody to work things out in a level of understanding. So I'm here today, and this is my first time here. I did, trauma informed is something that it takes a lot to know and understand. But also I want to talk to you about, I'm sorry I didn't know there was this many people, but when I usually go to conferences or I'm in training or I'm somewhere else, I usually take pictures with my phone. So I would like to pass out these that I print. I volunteer and do everything on my own because I care. And I want to be able to pass these out, and if you could share and read the different levels of racism and what is racial justice and different things that are very, very important. And I'd like to thank you for your time. Have a wonderful day.
Thank you. The next speaker will be Scott Reevestick.
Hello, I'm Scott Reevestack, and I'm chairman of my local drainage district, and I'm here tonight because I think the county board needs to be aware of some issues that we've been having. I understand, and you're all probably aware of the issues with the late distribution of taxes and things like that to the districts. And I understand there were problems with that, but my concern is even a little more basic. As a drainage district commissioner, our districts rely on the county treasurer to provide all our financial information, all our accounting, and our check distributions. And we're required by law to have an annual meeting every year in November. And in one of the functions in those meetings, we are required to approve a financial report. Well, this is a basic accounting report with all our income and expenses, and the treasurer was unable to provide a report. I don't know why but we were unable to get a report, so we had to continue our annual meeting till such time that we can get a report from the treasurer's office that has and we're not talking a huge thing. This is a drainage district. We're talking maybe 20 accounting entries. And we have been unable to receive that report despite having a couple requests. And to me, this is a far more serious issue than even not getting the tax monies distributed on time, because we can't do our jobs as we're required to do by statute. And I don't know where the problem is. I don't even know if this is the right forum to be addressing it, but if there's some way that you could assist the treasurer's office in getting these reports out and getting these things accomplished, it would be greatly appreciated, because it makes life much more difficult as a government entity not to be able to get a financial report to show to your taxing district and people there. It's an issue that I think you need to be aware of. I'm not sure you have the authority to act or do anything, but if you could provide assistance to the treasurer's office so these things be accomplished, there's many drainage districts that would greatly appreciate it.
Thank you. And the last person I have on my list here tonight is Laurel Pressing.
Well, it came to talk about tax fairness. I'm the tax collector, and what I found is that the current tax system has the highest penalties on the lowest income people. A homeowner who's late paying property taxes has to pay a 1.5% penalty per month, but a mobile home owner must pay $25 per month for the first 4 months. So for two people, if they paid their bill 4 months late, the homeowner penalty would be 6% of the original bill, and this would have been $97.23 on my house if I had paid my taxes late, which I didn't, I want to assure you. For a mobile home owner, the penalty would be 144% of the original tax bill. It would be a $110 penalty on an initial tax of $69.30. So the penalty would be bigger than the tax itself. So I think one reasonable approach would be to change the late penalty to 1.5% for everybody. I think that would be more fair. And I've talked to I brought this up at the meeting our local legislators had, Carol Ammons and Scott Bennett, to sponsor a bill. But I would hope that the county board would want to be involved in discussing this and seeing if you'd like to support that kind of a change. So thank you very much.
Okay, thank you. All right, any other members of the public wish to speak tonight? Okay, thank you. We're closing participation. Next is the consent agenda. This requires a roll call vote. Can I get a motion? Mr. Esri? Mr. Storr? Any discussion? Okay, would the clerk read the roll, please?
Dillard Meyer, Eisenman,
Yes.
Esri,
Yes.
Furtado, Goss,
Yes.
Harper,
Yes.
McGuire,
Yes.
Patterson, Rector,
Yes.
Storr, Summers,
Yes.
Taylor,
Yes.
Thorsland,
Yes.
Tinsley,
Yes.
Vachaspati,
Yes.
Wolkin, Young,
Yes.
Clemens,
Yes.
Court.
Yes.
Okay, motion carries. Thank you. Next is communications, and tonight we start with Carol Ammons, who is the 103rd District Representative for our area.
Thank you and good evening. It's a little bit of a reminiscent space for me to be in the county board meeting room this evening, and I'm certainly happy to see the reconfiguration of the space. We didn't quite have this kind of face-to-face when I was on the county board, and so I think it probably serves you better. Once again, good evening to the members of the Champaign County Board and to the public. Thank you to Chairman Rosales in his absence and County Executive Darlene Clopel for creating this opportunity for me to share my experience and legislative agenda with you all as you contemplate the next steps for the Champaign County Jail. As a former county board member, having served approximately 5.5 years, I sat on this board during the past examination of the conditions of the county jails. During that time, I served on the Community Justice Task Force in 2013. I also participated in the selection of the Institute for Law and Policy Planning, which is ILPP, the report, which is over 200 pages, which I will reference this evening as I submit to you my testimony. The report was issued September 24th, 2013. I've been working to advance pretrial justice for over 10 years. A few decades shy of what some of you may have been doing. However, even people who have relatively new to this work know that we are in a special moment. Half of a century after the Manhattan Bail Project first showed that money bail is unnecessary to assure court appearance, there is unprecedented growing demand for change. Far-reaching litigation is compelling jurisdictions to abruptly alter their practices, and local, state, and national lawmakers are honing in on plans for reformative and comprehensive reform. The Illinois Supreme Court Commission on Pretrial Services was created in 2017 and is comprised of members of all three branches of Illinois government and criminal justice stakeholders. I was appointed to that commission and started working on this process with the legislative body. It is charged with conducting a comprehensive review of the state's pretrial detention system and making recommendations for amendments to state laws, Illinois Supreme Court rules and policies as necessary to ensure pretrial practices in all jurisdictions in Illinois are consistent in form and substance with the court's policy statement on pretrial services. The commission is guided by the National Institute of Corrections, essential elements of a high-functioning pretrial system and agency, which has provided critical support and training to the Commission's efforts in improving Illinois bail practices. I've been a member of the Commission from the beginning of its creation and represent the House Democratic Caucus on the Commission. The purpose for my visit this evening is in relation to the impact of criminal justice reform on the court and jail systems in Illinois, and in particular, Champaign County. The Supreme Court Commission received communication from the United States Human Rights Commission. The important part of that communication was dealing specifically with pretrial practices and the impact on criminal justice reform, and in particular, the detaining of inmates prior to, or let me correct that, detaining of people pre-trial prior to being found guilty. The harms of money bail and pretrial incarceration. unnecessary use of pretrial incarceration betrays the presumption of innocence, a fundamental guiding principle of the U.S. legal system. By keeping people in jail who have not been convicted of a crime. Our report documented that between 2011 to 2015, close to 500,000 people in the United States were subject to felony arrests and held in pretrial detention, but never found to be guilty of any crime. With bail set, they face miserable conditions, options to take a heavy debt on bail, remaining in custody until their cases are resolved, or pleading guilty to gain freedom sooner, regardless of the act of guilt. Excuse me 1 second, it's kind of warm in here. The Human Rights Watch documented families losing homes, selling cars, and foregoing basic living necessities to afford bail. People who stay in jail lose jobs, cannot care for their children or disabled relatives, miss needed health care while suffering boredom, violence, and disease, and physical and mental anguish. In California, according to the Human Rights Watch analysis of data from 6 counties there, the vast majority of the people released from jail as sentenced on low-level felonies and misdemeanors were released before their earliest possible date of a trial. In other words, to assert their innocence at trial, they would have had to stay in jail longer than they would by pleading guilty. Practitioners throughout the county, including Illinois, have told us that similar pressure to plead guilty exists in their jurisdiction that use money bail. Given the coercion inherent in this choice, convictions of innocent people are inevitable. The large-scale use of pretrial detention resulting in pressured guilty pleas damages the credibility of our criminal legal system. These harms are more profound because they apply only to those who are too poor to pay bail, while the wealthy, technology doesn't work that way. Okay. These harms are more profound because they apply only to those too poor to pay bail, while the wealthy have the benefit of a system that honors the presumption of innocence. Given the well-documented inequities of the money bail system, the Human Rights Watch commends the many stakeholders in Illinois courts and government who are taking steps to reform the way courts impose pretrial incarceration. This is important because as you consider the conditions of the jail, either closing the downtown, and I certainly support that effort, and relocating any particular amount to the satellite jail, you must consider it within the framework of the presumption of innocence. A bail reform model created by John Raffling of the Human Rights Watch and Pete White of Los Angeles Community Action Network. This framework mandates cite and release. One of the provisions that the Illinois Supreme Court Commission on Pretrial Services will be considering. Cite and release means that if a person is arrested by any of our jurisdictions for low-level or nonviolent offenses, they will not see a day in the county jail. They will receive a citation and be released. Restriction detentions only to those who are violent felonies. This is one of the conditions that the Supreme Court Commission is considering a part of its official report, which will not be released this December as we thought. It will be released in April of 2020. But a part of that pretrial detainee provision, it will consider the court's rigorous hearings that will strictly require due process before ordering detention, bail, or restrictive release conditions, meaning electronic monitoring cannot be used as a replacement during pretrial unless the person has been actually found guilty. We forbid the use of profile-based or algorithms based on risk assessment tools. There is some discussion on whether we will use risk assessment tools within the recommendation of the Supreme Court. If the court orders some restrictive conditions of release, the court will bear all the costs of those conditions, meaning Champaign County will bear the cost of those restrictive conditions, not the individual or their families. We also recommend that there's reinvestment of money saved from the reduced incarceration into community development and community-based services that will improve safety without law enforcement having to be involved. Now, this is an important part of that. I pulled for you all from the report from ILPP that Champaign County paid for in 2013, the section on pretrial justice findings and recommendations. If the board has not reviewed the report from ILPP, I highly recommend it before you take taxpayer dollars and expand the county jail. The pretrial justice findings and recommendations within there, the first statement from ILPP says pretrial justice in Champaign County is woefully underdeveloped, leading to a system of inefficiencies, unnecessary taxpayer costs, and possible inherent inequities in the initial handling of criminal cases. This results in unintended discrimination along racial lines and against minorities of all kind. Change in this area is greatly needed for the furthering of Champaign County's criminal justice system and its stakeholders, and will save a significant amount of resources, lightening the demand for jail beds and reduce workloads throughout the system. Furthermore, it will free up resources and help Champaign focus more clearly on public safety priorities. It also went on and stated a multitude of recommendations for which I will not read to you this evening, but would encourage you to take an opportunity to read the report prior to making any additional decisions on structural changes to the county jail. In closing, I want to share a few thoughts on the presumption of innocence. As a legislator, we have no less than 15 bills on the docket in the spring that will impact the criminal justice system, the courts, and the jail system. Many of those are based on the presumption of innocence model, a new model for bail reform. The process of that, which has been instituted in Washington, D.C. for about 25 years, and in that institution, Washington, D.C. only holds violent felonies in their county jail, which means that only about 10% of those who are arrested are actually going to spend time in the county jail in Washington, D.C. We've also seen that trend in New Jersey, who also implemented pretrial reform. In New Jersey, we saw a stark decrease of pretrial detainees in their county jail, something of 55%. The purpose of preserving the presumption of innocence, the purpose of this system is to follow the Constitution. People are actually innocent until proven guilty. But if we arrest and detain people without warrant, without substantial risk of harm to themselves or the public, we are actually violating their right to the presumption of innocence. All people arrested for misdemeanors and low-level felonies and for higher-level felonies that do not actually allege actual physical harm or threat of harm are going to be recommended released until they are to come to court. Which means that if we, by way of criminal justice reform, either legislatively or administratively, meaning the Supreme Court order or the legislative orders by laws, we will again impact the number of people that are going to be held in any facility in Champaign County. We've already seen a reduction from 2017 pretrial reform that we started in 2017 that showed a reduction of 32% in pretrial detainees in Champaign County. We will see predicting about 21 to 25 additional percent in decline of those who are detained pretrial. All people arrested should have the presumption of innocence prior to appearing in court. It is important that Champaign County considers putting in place a separate pretrial services organization as it was recommended in ILPP's report. It is certainly more cost-effective than expanding the county jail. The new proposal will not be released, and it is not officially released until the Supreme Court accepts it in April. It will contain several provisions that will impact the entire state of Illinois, not just Champaign County. We intend to provide, under the actual model of the Supreme Court, the innocence until proven guilty model, and that will require less dependence on cash bail as a condition for release. That does not mean cash bail will be prohibited by the Supreme Court, but it may be prohibited by legislative measures. We do know that it will be superfluous in its use determining people's release. Finally, I had an opportunity to meet with our state's attorney and the sheriff on these same conditions. And during our conversation, it was clear to me that more work needed to be done to understand how pretrial, which we don't have necessarily an official pretrial services organization or department in Champaign County, how it works and how it will impact the county jail. I do believe that you, as legislative members of this local body, should take the opportunity to review the research that have already been done, much of which I have been sharing with you, so that you can read the documents and the trends that are taking place across the country. It is imperative that you do that so that you have full knowledge of what the expectation of the public would be when we shift from the reliance of cash bail to a presumption of innocence model. And with that, I am happy to take any of your questions my staff is going to tell me I didn't do something, so I'll do it. I'll do it before I close. So I want to go back and make sure that we understand just a couple of important parts just in closing. New Jersey, their overall jail population dropped by 6,000 people, 6,000 fewer people from 2012 to 2018 in their pretrial justice system. Of those, there were 3,000 fewer Black defendants. Over half of them were Black. 1,500 fewer white defendants. 1,300 fewer Hispanic defendants in 2018. That is after New Jersey implemented pretrial reforms. In California, they experienced the exact same thing, except in California, they have bail bondsmen. In Illinois, we got rid of bail bondsmen a very long time ago. And I find it to be interesting that in California, although they saw a sharp decline in inmates in their county jail, they saw some pushback from the bail bonds industry who's trying to repeal that provision. In Oklahoma, according to data collected from Oklahoma state courts, the average increase for non-monetary release over 5 counties statewide is 21.8% and growing. Oklahoma saw less people detained than all of those studies across the country except Washington, D.C. The consensus is laws drafted and passed in states across the country have many things in common, but one very important thing for consideration is that when you implement pretrial reforms, it actually flips the system on its head. Instead of operating where cash bail is the default if you have it, these new laws trending across the country place the burden of proof on the prosecutor's office and not the civilians. Processes have been put in place so that the prosecutor must file a motion to request pretrial detention, and in hearings, they must prove that the individual to be detained is a physical danger to others. In conclusion, as we continue to study the trends in pretrial reform across the country, I hope that we're able to actually flip our own perspective. I will share with you just briefly what our experience was the first day that the Supreme Court Commission organized itself as a commission. It was very difficult for all of the stakeholders to understand the presumption of innocent clause. Let me remind you that the Supreme Court Commission is filled with judges, lawyers, state's attorneys, sheriffs, public defenders, and legislators. But the concept of presumption of innocence was difficult to grasp. 2 years later, many of the members on the Supreme Court Commission have agreed that it is necessary for us to do the reforms statewide. We will not do it by Cook County only. We will not do it by Champaign County. We will do it as a collective state. I hope that we will be able to flip our perspectives as well, realizing that the actions have consequences and cause a chain reaction. If we insert Champaign County into any of the exercises that I shared with you, what would happen to our county jail? Let's say we do build a jail for $47 million and add that 100 beds. The trends will continue to show that pretrial reforms under the presumption of innocence framework results in less jail time for fewer and fewer people. We would have spent somewhat of $47 million or more on a jail that we cannot fill or pay for. And there's a flaw with this thought process. It's about money, profit, revenue, and not necessarily people. Now let's flip the tables again. And we choose not to build a jail. And instead, we implement a presumption of innocence law that allows us to manage our criminal justice system humanely. We save the taxpayers money. We also force the bail bond companies in other states to pay attention to what we're doing in Illinois. We build homelessness shelters and soup kitchens instead of using the county jail for those who don't have those resources. We return dignity to our citizens and our community. And this should be really about the people and what we do with their tax dollars. With that, I will close and thank you for your attention, and I'm happy to answer any questions that you may have.
Can we ask questions?
Okay, do you have questions?
Yeah. That was really awesome, State Representative Kara
Thank you.
Adams. I appreciate that a lot. Just real quick, did you send this report to us? I can't remember.
Which the Human
The one
Watch,
that you was citing tonight.
I'll be happy to send the Human Watch report to you that I cited. I will send that to all of the members.
Okay. And one other thing, the outcome that you was talking about, if you flip the script, is that statistically based? Is that research based or?
Those are all stats from the states themselves, and they are inside of the documents that we sent you, but we had to compile them ourselves because they
Gotcha.
don't lay them out as clearly.
All right. Excellent job.
Mr. Summers?
Help me out, I dropped the ball when I was taking notes. When was the ILPP study performed?
September of 2013, I want to say it is, or 2014.
Thank you.
Yeah.
Ms. Furtado?
You had mentioned that there's already several bills that are being considered for the spring. Do you anticipate with the pushback to April with the Supreme Court report coming out, do you anticipate more bills, or is that going to change the timeline? So based on that report, do you anticipate additional sort of legislative action for the spring session?
Yeah, I can't speak to what other members will prefer to do. We have held those bills for the last 2 years, anticipating the Supreme Court's report. I don't know if members will want to continue to hold them beyond the spring session, but we will do, based on the recommendations from the Supreme Court, we will have to change several statutes around the criminal justice issue.
Ms. Eisenman?
Hi there. I just want to clarify or double check when it says the cite and release, like so they would be cited for whatever it is. If they were like driving under the influence of alcohol, would they be detained until they are no longer under the
By
influence?
statute, they have to be detained
Okay.
under DUI.
Because they would be considered a dangerous threat to
Yes.
others. Okay.
Yes. And that would remain. There are several statutes that will change, but DUI is not one of them. Although we did pass a law last session to allow people to have some remediation under DUI, but on the initial contact, that will still be a visit to the county jail.
Mr. Richter?
Yeah, I'm just trying to understand the state Supreme Court Commission. So the Supreme Court is judicial. So I'm confused. I'm not disputing any content or
I
your
get it.
delivery. I'm just trying to understand the State Supreme Court Commission and how that relates to the State Supreme Court. It just seems like it's not judicial, and maybe you explain that and just.
Sure.
So-
It is a little complicated, but the Supreme Court has the authority to institute its own commissions to study any particular topic around the criminal justice issue. They, initially, the committee that worked on this prior to the commission was somewhat of an ad hoc committee. The Supreme Court had a member from the administrative office of the courts that participated on the original committee. But the Chief Justice decided that they would want to take a comprehensive look instead of just cash bail, because initially it was just cash bail. They initiated a commission's report from the Chief Justice, established the commission, and then reached out to the legislative body to appoint members to their commission. And so they are in complete control of the outcome of the report. You're welcome.
Mr. Storr?
Thank you. Thank you for coming to the county board, Representative Ammons. Was the commission that you were referring to the one that came, had held hearing last spring, I believe, or?
Yes.
Okay. And the Chief Justice Garman, I believe, came for that hearing.
Chief Justice Garman was one of the original members on the original committee. And once there was a new Chief Justice, Chief Justice Stuckert is the new chair of that commission now.
And I will say from my own experience in working with the mental health group that meets weekly at the satellite jail, that I concur with a lot of what Representative Ammons said, and that some of the people that are in the mental health group are, in fact, just being held until they can plead their case. And thank you.
A lot of the issues on the mental health is really the lack of funding from the state level. At one point, there was just a significant decline in funding for community-based mental health services. We are interested in taking that issue up and providing resources through our Department of Human Services around mental health services in the community. And that will be part of the responsibility of the state to make sure that we provide funding for that, so that county jails are not used as mental health facilities or holding facilities for people with mental illness.
This is certainly wonderful to hear. Thank you and thanks to the members of the General Assembly who are supporting this.
Thorsland?
Yeah, thank you, Carol, for coming. You know I have a little teeny part of innocence before proven guilty, and it has to do with from the moment you're arrested, the presumption that you're guilty starts to stack up against you. One of the things that starts is that mugshot that gets taken and put up. It happens almost instantaneously now. That's something that I would love to see folded into some of this reform. It's going to take some state legislative work. We can do some work here on the county. They say it's impossible, but I disagree with that. I think that this entire jail conversation, as Representative Ammons points out, needs to look at this pretrial reform, this lack of cash bail, and what do we really need, and what can we do with the money not spent on expanding the jail. There's many other things we can expand. Imagine what you could do with half of that money in the community if you're not building cells. Thank you very much for coming.
Thank you.
Did you want to say something, Kyle? Mr. Patterson?
Thanks for coming out tonight, and thanks to you and your staff for preparing this information for us. The report is supposed to go out in April.
The report is supposed to come out in April. Well, let me correct that. I don't believe the report will come out actually in April. We will conclude our work in April. We've asked for an extension because they are writing the report, so it may take us a little longer. I hope that it will come out in April. I do believe that there will be reform bills passed in this spring session, though.
Okay. And did you expect at the time the report is released that there would be Supreme Court rule changes, or how does that process?
I can't really speak to that because that is completely up to the Supreme Court to determine
just
which
hypothetically.
recommendations. They will determine which recommendations they will accept and use administrative authority to implement. And we have a legislative part that we will implement. So I think there may be some time delay on the Supreme Court's implementation based on their process. And I can't really speak to their process.
Right, thanks.
Mr. Young?
Sorry, this came to my mind. It happens sometime as you get old. Real quick, help me understand, how does state-by-state legislation laws work, especially if they like sensitive bills or controversial bills? Is there like a trial and error, like a 6-month probation to really see how does they work? If you understand what I'm trying to say, you see what I'm saying?
I think
Like,
so. Sometimes
that have
we,
to take that
we
into
do
account
we
too.
do pilots. For instance, we did a
Okay.
pilot pretrial services bill in Cook County in 2017. That was implemented with Sheriff Dart, and they immediately went from 10,000 in Cook County Jail to 5,000 or less in Cook County Jail. So once they implemented the pretrial practices in Cook County, they saw a 50% decline in arrestees detained pretrial. That was through the pilot, but of course they've adopted it because Chief Judge Evans did an executive order in Cook County to make it permanent.
What I'm trying to say is, how do we really know if something's going to work in another city or county? Do they have some, you see what I'm saying, sometimes
mean, we-
probational,
we-
just to see,
yeah.
you weigh out the pros and cons, you test it and see if it's really going to work
Yeah.
according to different states,
Well,
counties?
our consultant is the National Institute of Corrections, which also consulted here in Champaign County a few reports back. And the NIC has done a ton of research and followed states' implementation of pretrial services. And what they've seen is just pretty consistent across the board. Now, each state may have different, a little bit here, a little bit different there. Oklahoma slightly different from Arkansas or New Jersey. Washington, D.C. has a different process. But they have some commonalities as far as elements of pretrial practices, which are researched by NIC and are studied over and over again, and they have been found to be consistent.
Mr. Tinsley?
Thank you. Thank you, Representative Ammons, for coming and giving this presentation. I think it is so awesome, and I really feel like this criminal justice system could really benefit from this in regards to lightening the jail population. My question is, you spoke on how certain states that have that utilize the bail bondsman business, like how this is impacting them. Do you think this could have an effect here in Illinois on the plea deals within, I guess, within our state's attorneys' prosecution rates? You know, as
Yeah.
in regards to a lot of, defendants not having cash bond, having to await pretrial while being incarcerated in the county jail, and that pressure to just get out or to take whatever they have coming. Do you see that having an effect on those numbers, Lauren?
I do, and there's evidence in the reports that I've sent you. There's supportive evidence that a person who is out on bail or their own recognizance or whatever provisions they've been released, if that person is released and they're able to fight their case from outside, the research shows us that they have a better chance of getting a better outcome in their case. If they're on the inside, it's hard for them to advocate for themselves from the county jail, which is why the pretrial issue is such a big issue, because a person is actually innocent and had not been proven guilty yet. People who are in the county jail that are there waiting to be sent to DOC, that's a different population that has nothing to do with pretrial at all. And so we have seen significant differences in outcomes for a person who has enough money to pay that bail, to get out, to get a private attorney, to advocate for them if they have those resources. versus a person who literally get day to day. I know you guys probably know about the day to day. So if I'm in the county jail and I don't have enough money to get out and my bond is $1,000, I can sit there, and the reform of 2017 said you have to issue a credit of $30 a day. And so either that $30 a day will take it down enough so that I can scrounge up maybe $500 to get out, but I may have sat there for 2 or 3 weeks before I could get to that point to earn the $30 a day. I don't necessarily like that, but that's what happened in 2017. And so people do get a credit per day until their bail is within reach, so to speak. In my view from the Supreme Court Commission, that's not necessarily the best practice on pretrial. And so we are working around implementation of pretrial services that would support people getting to their court dates on time. People just simply forget, or don't have childcare, or don't have transportation, or so many other reasons that are documented why people don't make it to court on time. But our rate of failure to appear is really low in Champaign County, so that is not our issue.
Okay, Ms. Eisenman?
I have one more question. When you were talking about Cook County, it gave me a question. When you had said that they went from having 10,000 people detained to 5,000, do you have any data on the post-trial? Like, so out of the 5,000 that were not held at the time of the crime, do we know the follow-up, like they were later?
I don't have that with me. I was not able to find the statistics. I'm sure they have them. And I think I understand your question to mean that those who were not detained, how many of them were
Or later.
ultimately found
Yeah.
guilty and sent to DOC or whatever the case may have been. I don't know that part of that. I don't know if they've had enough time with the program as a pilot
That's what I
to
wondered,
collect that level of data. But I will ask for them, and if they do, I will be happy to send it to you
That
all.
would be great. I thought it would be interesting to see.
I'm certain my staff is taking notes of that.
Okay, perfect. Thank you.
Okay, thank you for coming.
Thank you so much for your time, and please let me know if I'm sending you too much information, but I'm happy to share anything I have.
Okay. Okay, are there any other communications from the board members? Seeing none, we will move on to approval of the minutes. May the executive have an omnibus motion to approve the minutes for October 24th, 2019, Truth in Taxation hearing, and October 24th, 2019, regular meeting. Mr. Rector? Okay, I need a second. Ms. Taylor? Okay. Any discussion? Mr. Esri?
We're just going to note that I think everybody's probably seen it, but we have a corrected version at our table.
Yeah, there's a corrected version of the minutes from the regular meeting at your table that it was evidently sent out a little too soon. Okay, any discussion? Seeing none, those in favor? Aye. Those opposed? Motion carries. All right, next are the standing committees. The first one is the summary of action taken November 5th, 2019 from the County Facilities Committee is accepted and placed on file. The summary of action taken November 7th, 2019 from the Environment and Land Use Committee is accepted and placed on file. Would the elect chair like to make a motion regarding item 1?
Yes, thank you. I move adoption of ordinance number 2019-10, prohibiting cannabis business establishments.
Can I get a second? Mr. Clemens, any discussion? Mr. Esri?
Just a few notes. If you've seen the newspaper, I think they did a decent job of explaining it. This item comes from the ELEC committee, but there is no recommendation because it was a tie vote at the committee level, which by our board rules means that it advances, but there's no recommendation from the committee. As presented, the state's attorney's office has looked this over and is okay with it. It's passed the legal review. And should this pass and to be enforced, there would be needed subsequent amendments to the zoning ordinance and nuisance ordinance, which would mean going out for like public hearing at the ZBA and such, and then it would come back to us yet again after that. But if there were changes and stuff to be made, for sure. But the biggest thing is just, tie vote at the committee level, so it's not really a recommendation of the committee, but it comes to us anyway because of our board rules.
Mr. Hall is also here this evening if there's questions that way. Any other discussion? Mr. Vajraspati.
Yeah, I'll be voting against this. I think it's foolish for us to be prohibiting cannabis establishments in the unincorporated areas. First of all, we're leaving tax money on the table. Note that this applies not just to places that are selling cannabis, but also to places that are growing it or processing it, which I think, maybe there's not that much need for a dispensary out in, the unincorporated areas. But, I can see that a farmer might want to grow some, and I think that they should be allowed to do that in the unincorporated areas. They'd be allowed to, grow whatever else. And like I said, we're just leaving money on the table, tax money on the table. We're restricting what people can do. I mean, I'm not much of a libertarian, but I'm enough of a libertarian that I, don't want to go along with this.
Mr. Goss.
Yeah, just to clarify, farmers can't grow medicinal or recreational marijuana. They can grow hemp, which this does not affect. I will be supporting this. I represent a largely rural area, and I polled my constituency. I spent time with constituents in my district over the last 2 weeks after this came out of the ELUC committee, and I did not have a single person write me, text me, Facebook me, or hit me on Twitter that supported the business out in the unincorporated area. I had several people say that they had no issues with it in the incorporated areas. They felt like it belonged in the cities. They felt like it did not belong out in the countryside. So I will be supporting the prohibition of this.
Mr. Tinsley.
I just have a question. Would the unincorporated areas of the county benefit from the revenue generated from the marijuana business? No, would the unincorporated areas benefit from the revenue generated that was brought in from the incorporated areas of the county?
I guess to that specific question, the county coffers are going to benefit from the taxes because we've already voted to put a tax on it. But to specifically say that an unincorporated area is going to receive a benefit, any one particular area, if the business is not there, other than the fact that they're in the county, I would say no, they're not going to benefit any more than any other part of the county, because that money would be coming to the county as a whole to be spent by the county as a whole, unless I guess this body would, okay, there's a business in an incorporated area, we get the tax money from it, and then we specifically decide to take that money and use it for something in the unincorporated part of the county specifically. If we did something like that, I'm just throwing that out there, then I guess, yes, okay, that part of the unincorporated county would get a benefit from it. But otherwise, the unincorporated is just part of the county, so it's not going to benefit any more or any less than any other part of the county.
So the whole county would benefit from marijuana businesses being in the incorporated areas of the county?
I guess from a tax benefit, but that's not the only thing that a lot of people out in the unincorporated are looking at.
They're looking at the money.
Any other discussion? Ms. Eisenman.
Okay. I already know how most of you are going to vote, and so I just want to ask you all to stop and to just please listen to the other side for a moment. I just would like to see a show of hands because I'm a teacher and I just like to see hands. Do any of you live in rural or unincorporated currently Champaign County right now? Who? You do? Okay, I was just truly, I really don't know that. Thank you. So my heart in this issue is I grew up 4 miles from Penfield for 15 years. My dad and stepmom still live in that same home. I have 2 nieces that live in Penfield and 6 great nieces and nephews. I'm sitting here representing Randy and Corey Rademacher and their family, Jennifer and Brody Crozier and their family, Dan and Diane Hesterberg and their family, and like I said, my family, my actual family members. I went to school with the people from Penfield. My first job was at the Penfield grocery, not grocery store, grocery. I don't know, they didn't have enough room for grocery store. So these are my people, as the great Dr. Young says, like when I'm speaking on behalf of my people. And so when I look around and I hear Mr. Tinsley say they see the money, no, they are not for this. I'm sitting here representing them because I am rural community, and that's who I'm representing. And Mrs. Ammon said it when she was talking about the pretrial. We don't want to just look at money. We want to look at people. And so these are people coming to us and saying, we don't want this business here. And I've said it in ELOC a couple of times, so I'm sorry for you on ELOC. You've already heard it. But the message that there is nothing in Penfield except for a bar and then a business where I think they have floral. They do wedding flower on the side on weekends. That's not a full-time job. So my point is there is no other positive thing in this community for the children to do after school. There's not a school in Penfield because they consolidated with Armstrong. There is, so if you're going to bring in a bar and then a cannabis business, which I know you don't think is going to come, Mr. Thorsland, I hope you're right, but there's no, you're bringing in another negative. There's no positive for these kids. There's no alternative for them there's no after-school program. There's no community center. There's no big brother, big sister program. We are just saying, slow down. I talked to the sheriff last week, and I just said, it's like going down a water slide. Once you start, you can't stop and turn around. We're just saying, slow down. Let's watch and see how does it work in Champaign-Urbana, because we don't know. And again, that's what you even said this. Let's see how's it going to work in the other counties for the pretrial. How is it going to work in the city? Let's see what works and what doesn't. And Ms. Osterber alluded to this. When you live out in the country and you call 911, they aren't there in 5 and 10 minutes. One time we had to meet them in Penfield with my brother because they couldn't come all the way out to our house. They weren't sure how to get there. If you have any sort of problem, it's an hour. And like she said, sometimes they just don't show up. That is not safe for the people in the community. So when you look at the page 79, the actual ordinance, it says, the county has determined that the operation of cannabis business establishments would present adverse impacts upon the health, safety, and welfare of the residents. And that's where I'm at. There is not a good enough way for it to be regulated, for a cop or deputy to be on scene to help if there is any sort of problem. So there would be health and safety. And additional costs, burdens, and impacts upon law enforcement and regulatory operations. It is at least 30 miles to Penfield for a deputy to come and monitor, to be able to regulate it, to make sure they're following the rules, to following the laws. And so my whole thing is, we're not saying, no, cannabis is bad. We don't want it. And I know that there are great medicinal uses for it, but unfortunately, they don't want it in Penfield. They don't want it in the unincorporated areas. And so I'm just asking you who live in towns who are not representing these people to please stop and listen to what the people want.
Mr. Tinsley.
I hear what you're saying. I understand your plea. Now, with the new laws coming about with recreational marijuana shops, they're going to be mandated to have their own private security. So, like, they have to have, like, a security team on hand that's armed, you know, to make sure the safety of the establishment is regulated. Now, I mean, I understand what you guys are coming from, but, like, I live in District 11 where I got more liquor stores than I need in this area, with police sharking it daily, and they're not there to regulate the liquor stores. They're there to regulate the people. So, like, I mean, I want to be sympathetic to that need, but it's like, you know, those weed shops are going to be regulated. How many liquor stores did you say is in District 11? Next door to schools, churches, activity centers, you name it. Like, there's plenty enough negative temptations in there in my district. I understand what you're saying. I see it on a daily basis riding through District 11. I mean, that one recreational marijuana spot, which is going to be mandated, securitized, and the county will be benefiting from it. I just don't. I find it hard to be sympathetic to that notion.
Mr. Harper?
But you know which way I'm going? Probably. But I have to agree completely with Ms. Eisenman. Living in the small area, I'm near Royal, not far from Penfield. Lorraine, you've been through Royal. If you blink, you missed it. Jody's right. Let's see what happens in Champaign-Urbana. Yeah, I'm a beer drinker. I don't deny it. Really. But I know people that smoke pot. I'm not going to tell them they can't. I'm not, but we're not ready for it out there. St. Joe or Philo is probably the two biggest villages in my district. St. Joe has not made a decision. Today in the paper, Rantoul, which is probably outside of Champaign-Urbana, the largest village in the county, voted it down. I think we're trying to get ahead of the game here. There's nothing says we can't come back and revisit this. But you've heard me say before, it's been brought up by Jody and the Osters, law enforcement can take anywhere from a half an hour to an hour to get there. So I will be supporting this prohibition on this right now. Thank you.
Mr. Thorson?
Thank you. Well, I'm not in support of the prohibition. I was in support of the ordinance that would allow these businesses, and they're not, everyone talks about a retail shop. That's one of 6 or 7 uses. Talk about businesses that people spend a lot of money for the permit. As Mr. Tinsley talked about, they have tight regulations. They're not going to let a situation happen that jeopardizes a license that cost them $40K. That's the maximum. $10K is about the lowest. These are businesses that would be involved in transport. These are businesses that would be involved in craft growing. And as Mr. Tinsley also pointed out, the GOP was happily on board with taxing the business of marijuana in Champaign County if it was in the incorporated parts. And there will be a benefit to the whole county from revenue generated by that. On a federal level, yesterday, out of the Judiciary Committee, with a 24-10 vote, bipartisan support, came the MORE Act, the Marijuana Opportunity and Reinvestment and Expulsion Act. What this will do, should it go into effect, is decriminalize on a federal level marijuana. And it has a component that takes some of the revenue generated from these taxes, put it into the communities that are most hurt by the prohibition of marijuana. And these are the poor communities. These are racially biased communities. We talk about social justice and racial justice. We're looking for people in suits to invest in marijuana businesses while a kid in a hoodie who's got a joint in his pocket is sitting in the county lockup right now. Another thing that this MORE Act will do is allow the Small Business Administration to offer loans to cannabis-related businesses, not just the growing of it, but all of the businesses related to it. It decriminalizes the movement of money. It allows the Veterans Administration to prescribe medical marijuana to the people who go to the VA for help. And there's many medical uses for it. Overall, in the nation, 67% of adults in the nation support the decriminalization of marijuana and the legalization of these businesses. We would be not forward-looking, but looking backwards. I represent a
town district now, but 3 times I ran for Jim Goss's spot when it was John Jay sitting over there. I lived in rural Champaign County. I own farm ground in rural Champaign County. I worked my tail off in rural Champaign County. I know all about how long it takes the sheriff to get there when Jimmy John down the street's got a party at 4 a.m. on a Friday night, and I got to load a van for farmer's market at 5, and how long it takes him to get there. But I've also done ride-alongs with the sheriff deputies, 3 of them, and they do not, their only issue that I talked about on a deputy level was they want clear guidance when it comes to talking about impaired people, which, if we're driving to town to go back to Penfield, and if you think nobody smokes dope in Penfield, well then, yeah, I know you didn't say that. It's out there, and they're going to be driving, indulging on the road, and that's the stuff we need to focus on. And we can do that if we have the revenue from the business. So I don't support this. I would like to see it voted down so it can go back to ELOC and the zoning board in a proper ordinance that realistically looks at these businesses can be formulated and not an outright prohibition. We know that alcohol devastates families. My stepfather's an alcoholic. And as Mr. Tinsley and everyone else knows, alcohol is readily available. It's found by everyone. This is a drug that we should be talking about a prohibition on, but that didn't work. And it won't work, and this one won't either.
Mr. Vajraspati.
Yeah, I really appreciate a lot of things that have been said today. And I sort of think there is room for some compromise here. You know, I don't think that it's particularly likely that there's going to be any dispensaries opening up in rural Champaign County. You know, I think that like, and so like I guess that means I don't really have a problem like even though I think they shouldn't be prohibited, I guess like if we want to like make that official, that's one thing. But I do think that when we and I sort of really do respect Ms. Eisenman how you know maybe you don't want you know a pot shop opening up down the street from you. You know, I think it would be very convenient, but you know I sort of wonder if we can get to a point where we can say, you know, all right, let's say no to dispensing organizations, but maybe yes to some of the less like user-facing or consumer-facing businesses that might, you know, present more of a hazard to, that sort of have some of the concerns more apply to them that are outlined in this resolution. So, you know, maybe we can send this back to ELOC and work on having something that lets people sort of do the sort of businesses that don't really have that risk that people might want to operate in the unincorporated areas, like, you know, cultivation centers, like if someone wants to run a greenhouse or something, or if someone wants to run like some sort of like factory for extracting whatever, especially if it's for medicinal use from the cannabis, and especially, you know, if they're like one of these things is basically like you have a garage with vans in it that have like the appropriate security to transport cannabis, and like I think that's the sort of thing that like I think is maybe less objectionable to some of the people who might and tell me if I'm wrong, but that's the sort of thing that I think folks out there might find less objectionable and is sort of more likely to, you know, be the appropriate fit for those areas in the first place. So I mean, tell me if I'm crazy, but like, is that something that folks could get behind? Yeah, I mean, and I don't know if we want to do it now or if we want to send it back to ELOC to take a closer look at it, but can we just talk about that sort of idea?
Mr. McGuire.
Thank you. I think there's 2 parts to this. One is self-determination, and the other part is good public policy. Obviously, the cities have an opportunity to decide some of the things you're talking about, what they would like to see in a policy and a zoning regulation that they would like to see in their communities. And the issue in front of us right now is that we're deciding for what happens with the people that are in the rural areas of the county because they don't have an organization in their communities to determine that. And from what people have said, including people in the audience and the people I've talked to, is that the city of Champaign and Urbana have decided in the past that they do want. They've had municipal dispensaries. Obviously, they're moving toward having recreational marijuana. But the people in the rural areas, even to Rantoul's point, which is a larger community, have decided they don't want to have dispensaries. So either the rural areas are allowed to have self-determination to decide for themselves how they want to handle this issue, or they're not allowed to. Either they're allowed to vote for themselves what they want in their communities, or they're not allowed to do that or decide for themselves. And they do that through the rural county board members. And obviously, we have more understanding of what they might want. And they've said, and they're deciding that pretty well through all the communities that are large enough to decide through their village boards. And they're saying to us, they neither have the experience or knowledge in many cases, or they'd like to wait long enough to decide what's happening where in the community that has the most experience, which is Champaign-Urbana. They want to see what happens there. Instead of us deciding for them that we're smarter than they are, and they, for them, we're going to decide for them what they think is more important for their communities. I think they're making the right decisions because they have no idea what's going to happen in their communities. And they don't have the resources to do what you think they should be doing. Because they don't. They don't have the experience. I had a discussion with somebody the other day. I won't say who it is because I didn't get there. But as far as the dispensaries in Champaign are concerned, those dispensaries just didn't pop up. There are people behind them that had experience to put those dispensaries in and know their experiences for growers and infusers and everybody else. So they have a knowledge, they have the resources. Champaign-Urbana have the idea of what's going to happen. The state also controls the growers. We don't know how that's going to happen in the rural areas yet. But this is also bad policy to pass a law to allow those growers, because if all the small towns in the rural areas decide they don't want these dispensers, and there's only one other dispensary that's going to be allowed in the county, and we have a lower tax in the county, in the rural areas of the county, whoever comes in is going to want to take that spot in the rural area because it's only going to be a 3% tax rather than a 6% tax. And they're going to want to do it near one of those towns because of the market that's going to be created there. And it's likely to be Champaign-Urbana. The only problem is it's not going to be regulated like those cities are going to want to be regulated. So we are creating bad policy, zoning policy, by allowing by passing a rule that allows the dispensaries in the community, in the county.
Okay.
So if you want to question it, I think we should have John Hall come up and talk about that.
Okay. Yeah, Jim, I'm saying I absolutely, like, I understand where you're coming from, right? I understand why, like, folks might not want dispensaries in the rural areas, and I respect that, and I appreciate that. But what I'm saying is that, like, just because we ban dispensaries, it doesn't mean we have to ban everything related to the whole cannabis industry, right? Like, if someone wants to put a greenhouse on their property where they are, you know, under the appropriate security conditions and so on, where they're growing cannabis that gets sold in the cities or gets sold wherever else, or if someone wants to have a business that, like, transports a cannabis from the you know, from the farms with the appropriate security to wherever it gets processed. I'm saying that's a whole different, you know, a whole different thing than having a dispensary out in the rural areas. And so I was wondering if there's room for a compromise there, but maybe there it just isn't.
Well, and that's why I tried to address is that the cities of Champaign-Urbana have the most experience with dealing with all those things. Then,
But no one's gonna put a greenhouse up in the
then a
incorporated
town,
areas.
then a town of 200, 400, or 10,000, because they have no experience. They've had no understanding. They've had no facilities. They've had nothing. And even the growers are going to be inside, right? I think Jim would say that. Or the infusers, they would be inside. They'd be regulated by one of the cities, and that would be the experience. They would have the experience level, the police, and regulation be able to deal with those issues. Muhammad wouldn't have.
Okay. Ms. Dillard Myers.
I've done my research, and medical marijuana has been around for a long time. And I think a lot of my colleagues here know my point of view. I've actually had alcohol to devastate my family more so than any marijuana ever had. And there was an article in the paper, the News Gazette, dealing with a lot of these issues you guys are talking about. And a lot of the things that you guys are saying are true or really false. They say your town will not turn into a Woodstock. Labor professor said that cannabis is popular and widely used anyway. And I would believe that there's probably more cannabis use out in the country than there is in the city, because we're more likely to get caught than y'all are. Like you say, the police ain't around. The other thing, it says, one guy says, towns that says no marijuana dispensary could end up regretting it. And this guy was 75 graduate of Guy's College of Business here at the U of I. He's CFO of California's Cannabis Manufacturing Plus products. And he says that's something that you guys may regret. I'm not going to read this and take up our time, but I have this here, and anybody who wants to see it can see it. And these are real professionals, people who are well thought of in their area of expertise. And that's one of the things that I want to address tonight here. A lot of misnomers are running around. Now, if I'm going to set up a dispensary, I ain't going to Penfield with 200 people. That's for sure. Economics tells me, Econ 101 tells me 200 people ain't going to get me no profit after I spend all the money to set it up. But I can see people growing and processing and wanting to transport it. And I don't see why we should stop them from owning and operating businesses that's legal, working with legal products, you know. So that's my point of view. So if we want to really prohibit something, I would say start with alcohol, because in here it says more kids drink alcohol than smoke marijuana.
Ms. Furtado.
So this is something I don't talk about a lot. I grew up in a big Polish-Italian family, and my mom, when you grow up in a big family like that, I had 2 aunts and uncles who lived on my street. We lived on the corner, and they lived on either side of the street. And I was the oldest cousin. My cousin Sarah was in the middle, and my sister, and we grew up in each other's pockets. Her younger brother, my first year here, went and bought pot for a bunch of his friends. You know, it was an illegal act, and he got robbed, and he got killed and shot. And all I'm saying is this: there's consequences to deregulation. The idea that safety, and I'm not naive enough, I'm an historian, I understand that if pot had been legal in Ohio, I mean, I think my cousin would still be alive. I understand that's not how history works. And I also understand that it's not like overnight, if pot is, you know, just because it's become legal in Illinois, that doesn't mean the black market is going to go away. But I know my cousin enough, like, you know, to know that if he had had a legal option, that's what he would have done. And I would rather have a uniform, planned out, regulated industry then a mishmash of pockets of that aren't regulated and pockets that are regulated. And if you're on this side of the street, it's this. And if you're on this side of the street, it's something else. To me, that adds confusion. And you know, we as a state have decided that it's legal. That's where we're at. And also, as a historian, I know that the whole concept of dry counties, pocket prohibition, has never worked historically. So no matter what we pass today, in 10 years or something like that, they're going to be revisiting it. I would support Pranjal's idea of maybe taking out the dispensing, because I don't think that I agree with what several people have said, that a dispensary isn't probably going to go into some of these unincorporated areas. But Mr. McGuire has a point. They might, because we as a body have incentivized it through our tax vote. So there might be a situation where right on the edge of town, somebody puts it in because there's a and all of us voted for that. We, by our tax vote, incentivized, right, so I would support, if y'all wanted to, you know, the dispensary thing. I think that might be a good compromise. But I do want to talk about, I just wanted to say that there is also a safety and a personal cost on lack of regulation.
Mr. Storr, yeah. Yep.
Thank you. I see that Mr. Hall is in the audience, and I think that I'd sure like to have him explain how county zoning might affect some of these cannabis establishments. Could you please elaborate on that?
What exactly is your question?
Ooh, we didn't rehearse this well enough. That these cannabis establishments can't be just constructed anywhere. Many of these things kind of are subject to certain kinds of zoning. That, for example, you would probably not be able to kind of set up a dispensary, in a cornfield or something that's zoned for agriculture, and some of the cultivation and trucking businesses would have to be in their appropriate zoning area there, and I believe that there's a lot of, in some cases, these are, could be constructed by right, but perhaps they could also, they might also have to be, what's the word I'm looking for? Special use or conditional permits. Could you elaborate on that, please?
Well, the draft text amendment that ELUC reviewed had, for example, dispensaries allowed in the B4 district. Now, there's 1 or 2 lots of B4 zoning in Penfield. Small towns generally, the smaller villages that the county zones, generally there is a very limited amount of business zoning there. And so when you think of dispensaries, the text amendment would have allowed them in the same zoning districts where retail occurs. Infusers were to be allowed in primarily industrial districts. We don't have much industrial zoning around the county. It's mostly around Champaign-Urbana. The transportation, again, that's sort of the business and industrial classification. The cultivation centers and the craft growers, I mean, I think that it really just amounts to agriculture. It's a very specific kind of agriculture, but it's growing the product. And it's not clear to me that the county can regulate that at all. I suspect the state's attorney will have to answer that question eventually. But yeah, so these things in the text amendment, they were based on similar uses, similar zoning districts, but there are pockets of business zoning in the small villages that the county zones. There's not much, but there's some. It would be possible to structure a text amendment that would allow things like dispensaries only within 1.5 miles of a home rule municipality. There's 3 home rule municipalities in the county: Champaign-Urbana and Rantoul. Rantoul has decided not to allow cannabis businesses, and so, you know, that's something to keep in mind.
Thank you. Now, historically, some communities in Champaign County were dry, were they not?
Yes.
And some of them became wet fairly recently. Is that the case?
That's true.
Okay. Just thank you very much.
Okay, Mr. Esri.
Yes, thank you. I was going to try and speak to Mr. Vachaspati, your idea of a compromise, and along the lines of just what happened at ELUC. We had this at our meeting for at ELUC committee for 2 meetings. Mr. Hall and his staff, I think correctly, they basically presented us with, at the last ELUC meeting this month, 2 resolutions. There was the one for the text amendments that would allow these businesses by right in the appropriate zoning. That was defeated because of the way our board policies work. It was a tie vote. And since the next step there would have been to go to the ZBA, a tie is a fail. Our second resolution was a out and out prohibition, which is what we see before us now, which again, tie vote. Since the next step for that is to come to the full vote, because this is a new ordinance, it's not just a text amendment. That's why it's here before us. So I'm just basically saying, I think they did the right thing. They presented us basically with the 2 extremes because they don't know where the committee, I mean, who are they? I mean, from a staffing point, I think that's right, because who are they to pick and choose where to start in the middle? I mean, I guess they could, but I think it's better, I think personally it's better for them to start it at the 2 extremes. But at neither one of the meetings was anything suggested as a compromise, like maybe the 1.5 miles, or maybe the 1.5 miles of a village or an incorporated area that has decided to allow it. So like, okay, Rantoul has their home rule and they have that 1.5 miles, but since they voted against it, or, it's written that we're not going to allow it there. But since Champaign-Urbana have, I mean, it's getting technical, but that's what can be done. Things like that can be done to where Champaign-Urbana allow it. So, okay, we'll allow it within the 1.5 miles of Champaign-Urbana in the unincorporated. But that would like be maybe address one of the issues of like Rantoul not wanting it. Well, they aren't going to then get one by our county zoning on their doorstep, because ultimately that is our zoning. So they could even, I forget if they have protest rights on that. John's shaking his head, they don't have protest rights even, but even if let's just even say they did, we would still potentially be able to say, because if enough people voted for it, nope, sorry, you're still going to get a dispensary right on your doorstep because we have the zoning. It would have to meet their regulations for the buildings and stuff like that. But that's, nothing like that was presented at ELUC. So just speaking to compromise, we had the 2 extremes, and as of right now in the ELUC, nothing was suggested that, well, hey, what if we do this? What if we do that? So that brings us up to where we are today.
Mr. McGuire.
Just going back to Champaign-Urbana, I hope that we would talk to them first, because obviously they have everyone all the way around the 1.5 miles of Champaign-Urbana, and they wouldn't, I mean, the the shop could be put anywhere and they wouldn't have any say-so of where that would be, it sounds like. So we'd want them to have some input into the zoning. I mean, and that's why I think that they're saying if it's an industrial location. They don't, huh? They don't get,
They don't get a say in where businesses decide to set up shop outside of Champaign-Urbana.
and that's the point. They would want to know and have some input on where it might go. Is it gonna be put next to a school? Is it gonna be, I mean, they have zoning and it's important to them to decide their zoning and where things are put.
Small government guy.
Huh?
Mr. Goss?
Yeah, I would be in favor of sending this back. I don't know, though, do we need to do it via motion to send it back to renegotiate or to negotiate?
Yeah, we can just, yeah, there's a motion on the table right now to approve this item. So it can
So
be
it'd be
voted
via
down,
amendment.
or it can just be voted down and then we can send it back, or, yeah.
Yeah, a couple things. One, you just said exactly what I wanted to say. The way to start to work on a compromise, Aaron pointed out very well, and I think he's correct. We were given the black and white. At ELOC, ELOC is only 6 or 7 of us at any given time, 6 in this case, and both votes were tied. At ELOC, I didn't propose to start hashing this out in ELOC, partly because we knew exactly where everyone was going to vote, and there wasn't any hashing out to do. This is the bigger body, and the way to start to work on what Pranjal's talking about, what maybe Jim is starting to go for, is to vote this down. First we say no, then we come back and we start to work on it. We have time to do it, but the first step is to not vote on the prohibition, to vote no on this, so then we can begin the process. As far as Mr. McGuire, I say this only partially facetiously, but the county's in charge of what happens outside. There's always a debate about what's in the mile and a half. The towns, of course, want to control everything that happens outside of the town, but not have to fund any services for outside the town. They just want the benefit. And you can see this by annexation maps. They head for the rich neighborhood. They ignore the others. Mohammed's a perfect example of staying out of the poor neighborhood, or they would annex the biggest mobile home park in southern Illinois right away, but they don't. Where they go, they're trying to get Summit Ridge because the houses are big and they don't have to give them anything. The water's already there and the cops are already there. So we have the right to say that. I think what Rantoul's setting themselves up for is if there's a B zoning district, and there's very few, as Mr. Hall points out rightfully, they may very well get a dispensary right on the outside of their town. And that's not our fault. It's a state regulated industry. If it fits the zoning that we have, and Rantoul says we don't want it in the town, well, then somebody with an eye to the tax changes that are outside and the zoning and comes up with the permit money is going to locate it right outside of Rantoul. It's probably a fantastic business idea. But that's up to Rantoul. But the way to start working on what we need to do in this committee with the whole committee's input is to start tonight by voting this down.
Mr. Vashishpati?
I move to refer this back to committee. Just to clarify, that says, we send it back to ELUC and they hash it out and come back to us. That way no one has to deal with voting no on prohibition when they might not want to. And I hope this is something we can all get behind as a board.
Is there a
And I'd
motion
like
on the
to
floor?
Yeah,
I'd like to
I
second
make that motion.
All right, Mr. Storr seconds. Is there discussion on that motion to refer it back to committee?
Was there a motion on the floor already?
You can motion
No, I
to
mean
refer
before
back to
this
committee,
motion.
the motion to refer back to committee will supersede the original motion.
Okay. I wanted, my name was obviously addressed here. Obviously, I think it's important to try to work with the other communities in this county, including the cities of this county. I live in an unincorporated area in the county, in Cherry Hills, where there's a church nearby. And obviously, any business that moved in near, in that unincorporated area would have an impact on the people in Cherry Hills. So just sticking to any business where it's unzoned and unexpected would have an impact on those people. Whether it's Rantoul or anywhere, that you don't care, that's fine. But other people would care. And I think we should vote this up or down, not just send it back. I think we should send a message to the people in the county on whether that have decided and said they don't want the dispensaries in their small towns and not in the rural areas, and say who cares about what they think or who doesn't.
Is there any further discussion on the item to send this back to committee? Mr. Clemens?
I would say if we send this back to committee, that I would hope that the committee would take their time. Let's get this right the first time, because once we do this, there's no bringing it back. You know, if we allow them to do this, we're not going to be able to stop it if everything goes wrong. So let's get this right the first time. The majority of the people in the rural area do not want these. So let's get it right the first time.
Okay, Mr. Rector has called the question. Those in favor of sending this motion back to the
Have a
committee?
roll call.
There's a roll call. Would you read the roll, please?
Yes.
Those in favor, I guess, just vote.
Point of order, do we technically have to vote on calling the question?
Yeah, okay. Those who want to end debate? Aye. Those opposed? Okay. So we are now taking a roll call vote about sending this back to committee.
Vachespati made the motion, Mr. Storr seconded the motion.
What we voting on now?
Of the superseding motion to send back to ELUC. Dillard Meyer. Eisenman.
No.
Esri.
Yes.
Furtado. Goss.
Yes.
Harper.
Yes.
McGuire.
No.
Patterson.
Yes.
Rector. Storr.
Yes.
Summers.
Yes.
Taylor.
Yes.
Thorsland.
Yes.
Tinsley.
Yes.
Vachespati.
Yes.
Wolkin.
Yes.
Young.
Yes.
Clemens.
Yes.
Coert.
Okay, motion carries. This will be referred back to committee. Mr. Esri?
I just want to say one quick thing. Mr. Thorsland, you're exactly right in that I think we knew where all of us were standing. I think maybe both sides were maybe guilty of not coming to the middle. I mean, I personally think there's some room for some compromise. That's all I'm going to say.
Okay, moving on. Item 11C, Highway and Transportation. The summary of action taken at the Highway and Transportation Committee on November the 8th, 2019 is accepted and placed on file. And now we're on item 12, Areas of Responsibility. The summary of action taken on November 12th, 2019 at the Committee of the Whole meeting is accepted and placed on file. Number A, Policy, Personnel, and Appointments. Would the policy chair like to make the committee's recommendation on item 1?
Okay, 1, I move the adoption of resolution number 2019-333, appointing Danielle Chenoweth to the Public Aid Appeal Committee, term 12/1/2019 to 11/30/2021.
Second by Mr. Tinsley. Discussion? Seeing none, those in favor?
Aye.
Those opposed? Motion carries.
Number two, I move the adoption of ordinance number 2019-14 establishing cannabis, drugs, and alcohol use / abuse policies.
Second by Mr. Esri. Any discussion?
Since the last meeting, has there been an opportunity to run this policy by, I know it hasn't come to the Labor Committee, but has there been a labor management meeting or in any way, shape, or form, have we gotten feedback from the collective bargaining units?
Isak is here this evening. She can possibly talk about the research that went into this.
At this point right now, no. The primary goal has been simply getting the protection for the county in place and then taking a look at if there's ways that we need to reconsider this. There really is a cost for the fact that this is happening really quickly. And we're moving based on the recommendation by our liability firm to move forward with putting the recommended policies into place to protect the interests of the county as an employer. Because the interests for our employees are actually protected by ADA, the Human Rights Act, and the Privacy in the Workplace Act. But the primary tool for protecting us as an employer is the policy. And so the first step is getting the policy simply into place, and then we can always come back and take a look at revisions that need to be made.
I think the other question also came up, would the union contract supersede this policy, or would the
Yes.
policy supersede?
Yeah, the union contract will always supersede the county policy.
So, yeah, so you listed a bunch of different things, and I agree with all of those things that we need to consider. But the other thing that protects employees is their collective bargaining rights, and implementing a significant change in policy that will not impact the majority of our employees who are under CBA. To me, who are we actually passing this policy for? And so I'm not saying that I'm against, I think my colleague, Mr. Tinsley, brought up some actual substantive issues with the policy itself. But for me, how we've arrived at the policy means I'm not going to vote for a significant policy change for our employees if it has not been vetted through the procedures that are put into place for the vast majority of our employees. That's why we have these labor contracts. And to me, it seems like this is out of order. I understand that it was rushed, but it's not as if we didn't know that the vast majority of our employees are under CBAs. And so I feel like all this is going to do is to cause confusion. And I will say, I even talked to another person who runs one of our boards, and she was like, wait, does this even apply to us? Like, I'm so unclear, does this even apply to us? And I was like, honestly, I don't know. And so I think that I understand from the liability that we need to pass something, but just because we need to pass something doesn't mean that we shouldn't be bringing everybody to the table.
And that's actually that's a much bigger question, because that's true for all of our policies. That, especially since there isn't anyone who reports to the board, there's a challenge in terms of to whom do these apply, and primarily it's the non-bargaining employees who are essentially the managers and the people who work with, who manage and supervise the bargaining employees. At the same time, I'm concerned about the precedent of saying, let's not put this in, because it's going to be the same question for sexual harassment, for all of the policies, including the salary administration, right? All of our policies, there's a lot of questions that we need to address, but if we don't put the basic liability in place for the people who are doing the supervision, then the only people who are currently protected would then be the people who are under the bargaining agreements.
As policy chair, I'm going to start stepping my game up with some of these policy issues and start inviting some of these experts in to educate us more so that we can have deep conversations about the legalities and exchange ideas so that we can be more educated. So I will step my game up with that. But as regards of this ordinance, I will be voting no for right now. I personally need more information from experts. And I don't like to rush either. Thank you.
Mr. Storr.
I understand that we can, that if this is tweaked a bit and brought back by the December meeting, that would be sufficient time for our risk management, our risk managers, insurance people. Do I understand that correctly?
There probably need to be some direction about what you want tweaked.
Well, I think we've heard an awful lot of comments from some of the other board members, such as input from the collective bargaining units and so forth.
Yeah, this policy does not apply to the collective bargaining units. It applies to everyone that's not in a collective bargaining unit. That's how a policy works. I mean, our personnel policies work for the people that aren't in the bargaining units. The bargaining unit agreement is the standard for them. Mr. McGuire?
It's my understanding that this was something that the insurance company came up with, that we thought, at least in the beginning, would be best to protect the county from anything that would happen.
It's actually
Unless-
not by our insurance company. The county, our state's attorney's office, and our liability firm, and several of the biggest HR companies around the state of Illinois all work with the same legal firm in Chicago that are the subject matter experts. And they're actually the ones who are developing the policies that are the best practices, and those are recommended throughout the state. And so that's why these policies have been vetted by the state's attorney's office, because it comes through the legal firm in the state that does provide those recommendations. And so it's not quite as simple as saying tweaking things, and because part of it is then going back to the subject matter experts, and that actually could take more time.
Thank you. That's what I thought the answer would be, and I have a problem with trying to tweak something in 2 weeks by people that aren't necessarily have the same experience and knowledge, and bringing it back. I'd have more of a problem if that was done, voting for it.
Ms. Diller Myers?
I find some very interesting reading on page 96, specifically D, E, F, and G. Seems like D contradicts F and G. D, E, F, and G, specifically D, E, D, F, and G. D says illegal drugs, and it names cannabis. And then you go down to F, and it says cannabis or marijuana is prohibited. And then it says the CBD is prohibited. So D, to me, if I'm reading this right, would include both of those. Well, the G right now, but F come January 2020. I haven't read this whole thing, which I probably should have, but it's some very disturbing information here. Because if you are holding one group accountable for one set of rules and another group accountable for other set of rules, that's not right. Now, I know when we worked at the university, when the collective bargaining unit got something for us, they gave it to the rest of the people. Like, we fought for parking because they was charging us, they was charging the secretary making $20,000, the same thing they were charging the professor making $200,000. So we fought to get it equalized. So once they equalized it, they put a cap on it and they say everybody gets it. So I find that kind of disturbing. And I know we have a unique situation here where we have all these collective bargaining units and the county, but I think the language should be somewhat cohesive among all the groups. And somebody's gonna have to explain to me how F and G got on this page when D is up there and clearly says 2021 cannabis. So
Maybe it would be a good idea to invite the state's attorney to the next meeting.
yeah, or
Yes.
maybe you should start questioning your vendor.
Dr. Young been saying that forever. She need to come out. She don't like me.
Mr. Goss?
Yeah, just to clarify, page 96 is nothing more than definitions. So there's no contradictory here. It's definitions. This is, as was stated, is to protect the county. Now, I have no problem with, let's invite the state's attorney next month. That's great. But we're here to protect the county, and so that we are taken care of on January 1st. So we need to have the county protection in there. I realize that we can't do anything about the CBA. It's unfortunate that we weren't able to negotiate this with the bargaining groups, but this is to protect the county and to keep the county as protected in a liability case. So.
And just for a point of clarification, the bargaining completed before this was released by, because of the timing of the laws. So this was adapted according to the pending laws, and that wasn't released until after the bargaining was complete. And this is not only to protect the county, it's also to protect the county board and the board members from the liability.
And can I follow up on what he said about being definitions? It clearly says that, talks about drug testing and drug-free workplace. So there is some contradiction there.
Yeah, these are the legal definitions that would be used in the court of law. And the state's attorneys can address those questions more than I can. What I'd, however, do is recognize that since this has been vetted by our state's attorney's office in terms of the best interests of the county right now, based on what we know about the laws, and knowing that, in fact, this is going to be adapted probably several times over the next year, as one of the challenges is there isn't any case law, and so there isn't any precedent to identify or to expect how the new laws will be interpreted in court. And so these are the subject matter expert recommendations for best practices going into the first of the year to protect the counties, while we figure out, and we meaning the state of Illinois, while we figure out what these laws really mean in terms of how they're being interpreted in courts, and what the level of protections mean, and how the definitions will be represented in court. And right now, there's just not a whole lot of things that we don't know. Illinois is the 11th state to legalize cannabis, but it's actually the first state in the union to legalize cannabis through law. And so there are policy implications that will only be relevant in Illinois in a way that aren't relevant in other states. And so right now there's just so many things we don't know. And so again, this is just the best practice that's been recommended, knowing that there's a lot of things we don't know yet. But if we don't have protections in place, there's a risk to the taxpayers, to the county, as well as to the board members. And it is a work in progress, but there's a concern in terms of adapting based on what we think we understand, versus, especially since we don't have the case law to support that. And if we move away from what is recommended from the subject matter experts, we could be opening up the county and the board, including the board members, to liabilities that we can't anticipate at this point. This is uncharted territory in the state of Illinois. We're the only state who's right now dealing with a lot of these issues. And without any case law, without any precedent, there's a lot of things we just simply can't answer. But the liability exists even though that case law and that precedent has not yet been established.
I think the county board members should be able to make that decision, make that call. If we request the state's attorney office to come before us so we can ask questions, I think we have that right. I have reached out to the state's attorney office several times, along with emails, and she refused to come. Not only with this issue, with a lot of issue. Once again, ain't none of us no experts. So if we have questions, that's part of just being transparent. And thoughts come to our head at that moment. So we have a right to ask questions. And I hope she come and somebody invite her, because she said she wasn't coming on my behalf.
Mr. Tinsley.
Thank you, Dolly. Yeah, I mean, I'm not gonna support this, and I think I spoke on why I'm not. I really just don't want to see a non-union employee catch the short end of a stick off a policy issue that's trial and error. You know, that's just not fair. I mean, I understand like the county has to protect its own skin, but you know, we're talking about simple legalities that could pretty much just a person can lose their whole job over, and I mean, I can't get down with that.
Mr. Rector?
Yeah, I'm on policy committee with Dr. Charles, and I don't love this. I read it a bunch. I don't love it. There's some issues with it. I totally agree. But when your insurance company says, you guys want to protect your, you know what, and we're paying them X thousands of dollars on this liability, and ESOC's back there saying we need to do this, then let's do it and we can clean it up later. But if we sit here and don't put into effect what attorneys and our insurance company is telling us, then we're not doing the good business. I empathize with our employees. But we need to run this as a business. And as a business, they're saying, we have liability, we have exposure, you guys better put this policy in place. And I think we can deal with some of it, because there's some words in there I don't like too, the way it's worded. And we talked about this at caucus, that somebody has a 12-pack in their car out in the parking lot. There's some issues here and related to the cannabis. But if our insurance company says you need to put this in place and we don't, then we're making a mistake business-wise, in my opinion. Thank you.
Okay, Ms. Spotty?
Is there a sunset provision on this policy?
No. Our personnel policies are in place until they get replaced.
Okay. Yeah, can we put one? Can we say this policy expires in 6 months unless, and then we're forced to, because I sort of see where Mr. Rector's coming from, but, if we're going to look at it, then we better, sort of hardcore commit to looking at it, and I think that's the way to do it.
You could do that. I don't know if things will have changed in 6 months, or it might take a year. I don't know what the time would be, but normally policies are reviewed periodically. But yeah, you can put that in if you want to. Mr. Harper?
You're talking about insurance legal people, attorneys, and Mr. Rector, Mr. Goss. We have to protect ourselves by January 1. You cannot open yourself up to liability. Policies change all the time, and it will get tweaked as we learn more about all this stuff. But right now, each and every one of us here sitting here need to be protected, along with the rest of the county. It's best practice policy. ESOC just said that. As of right now, this is the best we know. As situations change, policies change, we update it and go from there. But right now, you have to protect everyone sitting in here.
Okay, are we ready for a vote? Mr. Spotty?
I want to offer an amendment saying, at the end of the ordinance, this policy shall cease to be effective on July 1st, 2020? June 1st, 2020. Let's go for June. Yeah, that's a motion.
This policy shall cease to be effective on June 20?
June 1.
June 1.
2020.
June 1 of 2020.
That should be enough time to get everyone who needs to look at it.
Who seconded that? Mr. Tinsley? Any discussion on the amendment?
I'd like to
Mr.
add an
McGuire?
amendment to the amendment. That it would be reviewed on July 20, 2020, instead of July 21st. Yeah, July 1st, 2020, rather than have it end.
Are you suggesting a friendly amendment to the amendment?
Yes.
Are you willing to accept the friendly amendment? No. Okay, we're back. All right, the way it reads right now is this policy shall cease to be effective June 1st, 2020. We're voting on the amendment. Those in favor?
Roll.
Those opposed?
Nay.
We need a hand vote or something to count. Will you do a roll call, please?
Hold up, what we voting on again?
We're voting on the amendment that the policy in front of you will cease to be effective June 1st, 2020.
I'm against, okay.
Can you do a roll call, please?
Yeah. Dillard Meyer. Eisenman.
No.
Esri.
No.
Furtado. Goss.
No.
Harper.
No.
McGuire.
No.
Patterson. Storr. The Rector.
Which
No.
one? Who's voting?
Storr.
Yes.
Summers.
Yes.
Taylor.
Yes.
Thorsland.
Yes.
Tinsley.
Yes.
Bachespati.
Yes.
Wolkin.
No.
Young.
Yes.
Clemens.
No.
Court.
Yes.
Okay, motion carries. So we go back to the adoption of the ordinance with the amendment. Any more discussion? Mr. McGuire?
Will our insurance accept it at only 6 months?
It's not up to the insurance, it really is up to the board. It certainly isn't the recommendation, because now if it were to carry, and if the board were unable to come to consensus, then effective that date, we wouldn't have any policy at all, and therefore no protection. Right, so that obviously wouldn't be the insurance company or state attorney's recommendation, right, but that's the vote on the table.
Any other discussion? Mr. Storr?
Sure. You know, in response to Mr. McGuire, if the board chooses, we can vote to adopt this without any end date at all before that time. This will just kind of be something that will have to be brought up in April or May.
Ms. Furtado?
And just, again, from my perspective, in order to get me to that yes, that golden yes vote in the sky, a couple of things. On page 98, we need a definition of the word volunteers. Like, this says that it also applies to volunteers, but I don't honestly know how is that operational. On page 99, there's an entire second paragraph that almost wholly only relates to employees that are under a CBA agreement. So if you're telling me that this whole policy does not apply to people that are under collective bargaining, take out the language that is specific to people within collective bargaining. You don't have to wait till a contract is open to call a labor management meeting. Do that at least baseline due diligence before the June meeting. Like, there's like some real practical, find out what Mr. Rector's issues are with it, and sort of, we have 6 months. I think that this is a decent compromise. I could tell you something on almost every single page I don't like about this policy. And so I think that, fine, we've CYA'd, so now we have 6 months to address it in a way that, because I question like the whole liability thing if we haven't tried to bargain this in any way, shape, or form. Like, what kind of insurance policy is it? Like the 22 employees that this applies to? Like, that doesn't. I don't really even get. I don't know enough about insurance, but I don't totally get how that covers us. But those are some of the issues that I have with it. But I think we have enough time, and we have like. Seems like a ton of study sessions on the agenda. maybe we could bring this into one of the study sessions.
Mr. Summers?
As a governmental body, if we have questions about something, the idea of moving forward to pass it when we have questions that we don't have answers to would mean we are not doing our jobs appropriately.
Okay, Mr. Fascispati?
Yeah, I just want to say I'm reluctant to pass this even with the sunset provision for the reasons that my colleagues have outlined. But you know, I I think that we're sort of in this unfortunate position because it took so long to get to this point.
Ready to vote? Those in favor? Those opposed? Okay, motion carries. Okay, we also have now an item 3 here that we moved down from the consent agenda, adoption of resolution. Would you make that motion, please?
Yes, item 3C, the policy committee recommend adoption of resolution 2019 to 334, Champaign County Board calendar of meetings.
Can I get a second? Mr. Patterson? Is there any discussion? Ms. Cowart?
The Highway Committee.
Will you talk into your microphone, please? So, yeah.
The Highway Committee proposes amendment to change the date of their Highway Committee meeting on October 9th to October 2nd.
So the highway engineer has proposed through the highway committee that there be a change to one of the dates on the agenda or the calendar in October from the 9th to the 2nd. So we needed to take it off the consent agenda to make an amendment. Any discussion on the amendment? I'm sorry, we need a second to the amendment. Mr. Summers? Any discussion on the amendment? Okay, those in favor?
Aye.
Those opposed? Motion carries. Now we go back to the original motion to approve the calendar for the year. Ms. Furtado?
Can you please make that beautiful color-coded calendar again? It's like it's on my refrigerator and it's changed my life.
Yes, we
Okay,
can do that.
thank you.
Once we get all our dates, we'll make the color-coded calendar. Okay. Those in favor?
Aye.
Those opposed? Motion carries. Thank you. All right, we're moving now
Excuse
to,
me, one moment. Who moved for the amendment to the calendar and who seconded?
Ms. Cowart made the motion coming from the highway committee, and Mr. Summers seconded the amendment.
And the approval of the calendar?
The original motion was made by the policy committee, so Dr. Young made that one.
Okay.
And who seconded? I'm not sure I remember. Ms. Cowart seconded.
Thank you very much.
Okay, we're moving on to finance. Would the finance chair make the committee's recommendation regarding item 1?
I move adoption of ordinance number 2019-8 FY 2020 annual tax levy ordinance, Champaign County.
Mr. Esri seconds. Can I get discussion? We've discussed this quite a bit, so let's go ahead and vote. Those in favor, this requires a roll call vote.
Dillard Myers? Eisenman?
Yes.
Esri?
Yes.
Furtado? Goss?
Yes.
Harper,
Yes.
McGuire,
Yes.
Patterson,
Yes.
Rector,
Yes.
Storr,
Yes.
Summers,
Yes.
Taylor,
Yes.
Thorsland,
Yes.
Tinsley,
Yes.
Vachaspati,
Yes.
Wolkin,
Yes.
Young,
Yes.
Clemens,
Yes.
Cowart.
Yes.
Okay, motion carries. Thank you. Would the finance chair make the committee's recommendation for item 2?
I move adoption of ordinance number 2019-9, FY 2020 annual budget and appropriation ordinance.
Seconded by Mr. Thorsland. Discussion? Those in favor? I'm sorry, again, roll call. Those in, yeah, read the roll, please.
Dillard Myers, Eisenman,
Yes.
Esri,
Yes.
Furtado, Goss,
Yes.
Harper. McGuire,
Yes.
Patterson,
Yes.
Rector,
Yes.
Storr,
Yes.
Summers,
Yes.
Taylor,
Yes.
Thorsland,
Yes.
Tinsley,
Yes.
Vachaspati,
Yes.
Wolkin,
Yes.
Young,
Yes.
Clemens,
Yes.
Cowart.
Motion carries. Thank you. Now we're at new business. Finance Committee, coming out of Finance would be adoption of resolution number 2019341, authorizing a budget amendment 19-00057, Fund 184 for the county bridge, Department 060 Highway, the increased appropriation for $935,000, increased revenue 0. The reason is to reserve funds needed to cover the county bridge projects on County Highway 15 and County Highway 18. The two bridge improvements were bid in the same fiscal year. The bridges were initially scheduled in 2 different years, but needed to be done at the same time due to their rapid deterioration. The current fund balance is $2 million plus or minus. Can the executive get a motion? Ms. Cowart? Second? Ms. Taylor? Any discussion? Mr. Goss?
Yeah, I'd like to correct that. That was Fund 084, not Fund 184.
Sorry, you read it wrong. Any other discussion? Okay, seeing none, those in favor? Roll call. This one's roll call plus 15.
Dillard Meyer, Eisenman,
Yes.
Esri,
Yes.
Furtado, Goss,
Yes.
Harper,
Yes.
McGuire,
Yes.
Patterson,
Yes.
Rector,
Yes.
Storr, Summers,
Yes.
Taylor,
Yes.
Thorsland,
Yes.
Tinsley,
Yes.
Vachaspati, Wolkin,
Yes.
Young,
Yes.
Clemens,
Yes.
Cowart.
Okay, the motion passes unanimously. Number 2, adoption of resolution number 2019-342, authorizing budget amendment 19-00056, Fund 671, court document storage, FD, from Department 030 of the Circuit Clerk. Increased appropriation $10,000, increased revenue 0. Reason, funds from fund balance. Amendment is needed to cover the cost of file folders for 2020. Can the executive get a motion? Mr. Goss, second by Ms. Taylor. And there's the circuit clerk. There's Katie's here tonight if you have questions.
Sure. I guess I must have got a little extra caffeine today. How soon, it was my understanding that we're trying to move to electronic filing for just about everything, and we bought some special forms last year or not so long ago, and now we're getting special file folders. When can we move to, when do you foresee finally moving to electronic just about everything?
That's a great question. So the file folders, we have always purchased special file folders. The form and labeling of those folders is determined by general administrative order from the Supreme Court. So if we have paper records, they have to be put in these special file folders. At one point, our budget for that annually was about $50,000. We had reduced the cost of that by going to various different vendors, and were able to reduce the cost to around $30,000. However, since the advent of e-filing, when the Supreme Court mandated e-filing on civil cases, that business, that industry has shrunk considerably. There are many vendors who went out of business. So there is about one vendor left in the that we can even purchase these very specialized file folders from. So that has increased our cost because they basically can charge us whatever they want. So civil cases are filed electronically, and we are required to accept them electronically. However, we are still required by the Champaign County Judiciary to print everything that is filed electronically and make up a court file to be delivered for use in court. There is one judge who has gone fully paperless, fully fileless in his courtroom, and that is Judge Baum, so please thank him if you see him. We are, so he has started that. And then there, a couple of other judges, Judge Rosenbaum has moved one call of his to a completely fileless, but he's testing that out and will hopefully move on to other calls. So I'm very hopeful that the judges who have begun using a fileless system in their courtroom will find success with that, and then we'll move forward in encouraging other judges to do so. There are many other counties that have gone completely fileless in their courtrooms, and some for even a few years. Many of the smaller counties south of Champaign County have been fileless for some time. So we are hopeful that will that we're very grateful for Judge Baum, and we really appreciate his willingness to try new things and to try a different system. So hopefully that will continue with the other judges. So we are exploring different options to assist judges in the courtroom, manage that their calendars without the paper files. Some judges will always prefer paper. So if we are ordered to do so, we do have to print that. And then if they are printed, they have to be placed in these very specialized folders.
Okay, those in favor of the motion? Oh, sorry about it. I'm sorry. I keep missing those little dots. Roll call vote, please. And this one also requires 15.
Dillard Meyer. Eisenman.
Yes.
Esri.
Yes.
Furtado. Goss.
Yes.
Harper.
Yes.
McGuire.
Yes.
Patterson. Rector.
Yes.
Storr.
No.
Summers.
Yes.
Taylor.
Yes.
Thorsland.
Yes.
Tinsley.
Yes.
Bachispati.
Yes.
Wolkin.
Yes.
Young.
Yes.
Clemens.
Yes.
Coert.
Okay, motion carries. Thanks, Katie. We're now to other business. This is the semi-annual review of closed session minutes, and I've asked Lorraine if she'll read the motion for that.
I make a motion to follow the state's attorney's recommendation to keep the previous closed session minutes closed.
Mr. Esri's second on that. Any discussion? We can't really discuss because it's closed session. If you want to discuss, we go into the other room. There were no closed session minutes to be opened at this time. Patterson, you want to go into the other room?
No, I have a question that's not related to the content of the
Procedural?
closed session. To clarify, because we have some confusion on this side of the room, we reviewed these at Cal, and then we are voting on all of the minutes that we reviewed at Cal, correct?
There were no, these are the board minute meetings from previous full board meetings, not the Cal minutes.
So
And there were none.
At the Cal meeting, we reviewed the, okay.
Yeah, the Cal meeting approves the Cal closed sessions.
It's been a long day.
And the board meeting approves the board meeting closed sessions. And there were none to bring before you that the state's attorney recommended opening at this time. Okay, those in favor? Those opposed? Thank you. Motion passes. All right, next we have item B. This is a request for an extension to file Champaign County Circuit Clerk's audit report for the year ending December 31st, 2018 with the Administrative Office of the Illinois Courts. And Katie is again here. Can I get a motion? Mr. Vachaspati, second Mr. Summers. Katie, do you have any comments about this?
I do want to clarify that this audit is tied to the county audit. It's just we have different statutory requirements. And so we are required to report to the Administrative Office of Illinois Courts, to the Supreme Court, our annual audit. We completed the portion asked of us by the outside auditors in April. We have still not received a report from the outside auditors. They did send us an email last week or 2 weeks ago with some additional requests, and we responded to that immediately. We have been in compliance. We have responded to everything they've asked of us. We just have not received anything from them yet.
Okay, Ms. Furtado.
I was trying to cast my mind back. We did this last year, right?
Yes,
Maybe
this
even a
same
couple of
outside
times.
auditor.
Okay.
I have some feelings about the outside auditor, but when the contract is up, you may want to consider looking at other firms.
All right, those in favor? Those opposed? Motion carries. Item C, do I have a motion for adoption of resolution number 2019-343, authorizing payment of claims? Ms. Cowart, second by Mr. Young. Discussion? Seeing none, those in favor? Those opposed? Motion carries. Item D, adoption of resolution number 2019-344, authorizing purchase not following purchasing policy. Can I get a motion? Mr. Vachaspati, second Ms. Cowart. Discussion. Those in favor? Those opposed? Motion carries. Oh, Mr. Vachaspati? Pardon? You want to add other business to the agenda? It's not on the agenda. We got, go ahead.
Can I say something
Is
real
it just
quick?
an announcement or so? Yeah, you can, okay,
Yeah,
go ahead.
I want to let you all know that I'm going to be resigning from the board effective basically as soon as I get to my computer and send an email to the chair. It's been a real privilege to serve with you all and to serve the people of Champaign County. And I wish you the best of luck in the coming years. And if anyone wants to hear more about what I'm doing with my life, I'm happy to talk to you after the meeting.
Thank you for your service on the board. The meeting is now adjourned.